Welcome to Landmark Chamber's webinar, Current Issues in Environmental Law Part 2, Public Participation, SCA and SSSIs. We are delighted to see so many of you joining the session today and hope that you'll find the presentations and discussion to be useful and informative. I'm afraid I'm not, as advertised, David Elvin QC. Unfortunately, due to technological issues, David's unable to chair the seminar today. So I'll be chairing it together with my colleagues, Andrew Byass and Matthew Dale Harris, who I'll introduce in more detail just before they give their presentations. To begin with, a few housekeeping points to note. Firstly, your microphones are automatically muted, so you will not need to adjust your local settings. Secondly, we very much welcome questions throughout the session. Please submit them via text in the Q&A section, which may be found at either the top or bottom of your screen. We will endeavour to answer as many questions as possible at the end of the presentation. However, if one unable to do so, we will follow up after the event. Thirdly, this webinar will be recorded. You will receive a link to the presentation and the recording shortly after the event concludes. If your connection is lost at any point during the webinar, we'll invite you to rejoin the meeting by clicking on the original link once again. The talks today have been designed to have a degree of interactivity and we'll be using an online software platform to ask questions of the audience. In order to access this, you'll either need to open a separate web browser or open the browser on another device and go to the link which will be displayed on the next slide. Once you've followed the link, the website will assign you a randomized username and you'll be able to answer the questions from that second browser or different device as they come up. We'll post the link into the chat on this meeting if you need to find it again during the presentation. So let us begin. This is the link I referred to a couple of moments ago. So if you go to that website address, you should come through to a screen which tells you that the presentation is about to begin. And then if you're asked to join a presentation, enter landmark C90. And as before, all usernames will be automatically generated in order to ensure anonymity. And Matthew Dale Harris has also posted that in the chat at the bottom, so I'm going to move on to the next slides. As mentioned before, there's three speakers today, my apologies. I'll be speaking first on public participation in Aarhus protections by way of an update. Andrew Byass will be speaking on SEA, scope of application and standard of review and update. And Matthew Dale Harris will be then speaking on the domestic competence regime, where now for SSSIs in post-Brexit Britain. So moving on firstly to public participation and Aarhus protections. I'm going to be covering briefly 4 topics today. Firstly, access to environmental information, some updates on the EIR context. Secondly, the issue of standing in legal challenges. Touching briefly on what is meant by effective public participation, so some recent updates, and then dealing with the issue of costs. But first, as we mentioned, the quiz, we thought we'd start with a few trial run questions to get the software up and running. So we move on firstly to our warm-up quiz. You'll have seen something flash up at the bottom that says speed counts and get ready to compete. What will happen is as I click through the slides, there'll usually be about 10 seconds or so to answer the question. And again, please do that on your second device. We will try practicing this morning by clicking on the screen in front of us and it doesn't work. So moving on to question 1. How many countries are signatories to the Aarhus Convention? And the 10 seconds will start when I click to the next screen, I believe. So the options are 46, 42, or 38. So, time's up on that one. And the correct answer was 46, and we can see that 44% of you got that answer correct. Moving on to the second question. Oh, no, forgive me, we get a leaderboard, and as you'll see, the randomly generated names are comic value, if nothing else. So the second question, which of the following is not a signatory to the convention? And again, the 10 seconds will start when I click to the next slide. And moving on to the answers, the correct answer is Turkey with a 30% success rate. And we can see on the slide what that has done to the leaderboard. And then finally, just our third warm-up question. According to TripAdvisor, what is the most popular attraction in Aarhus? And our options are the Aarhus Music Goods. Oh, sorry, I'm not even going to try and pronounce these. There's 4 options. And the correct answer is number 2, the Musgard Museum. And I understand from Matthew Dale Harris, who certainly set this question, that is home to an ancient man who, and is one of the most visited attractions in the area. And in terms of the leaderboard, we can see in equal first place we have famed Cuddly Dawn, equal Sunny Creek, and famous Earthy Tundra. So congratulations all, and I will move on now to the substance of my presentation. So I just wanted to touch on 3 issues that have been the subject of some recent decisions by the ICO or the tribunals in the context of access to environmental information. So the first pillar, as it were, under the Aarhus Convention. Firstly, the age-old question of who is a public authority. 2 fairly big decisions on this in the last year or so. One more procedural, that's the E.ON case, which is the first case on the slide. And this was a case where Fish Legal had made a request for information to E.ON in respect of the Rampion offshore wind farm. E.ON didn't respond to the request, but then when it went to the Information Commissioner, they said they were not a public authority and they didn't in any event hold the information that was requested. The Information Commissioner served an information notice under Section 51, seeking further information to enable it to determine or consider the request. E.ON appealed against the notice. When it got to the first tier tribunal, the arguments were really around E.ON saying, well, we don't even hold the information. Why was this notice served? It was disproportionate. You could, in any event, you could have worked out if we're a public authority from publicly available information. But the first tier tribunal took the view that it needed to deal with this public authority issue as a preliminary issue, because that was fundamental to firstly the ICO's jurisdiction and then subsequently to its own jurisdiction. So the first tier tribunal made its determination. It went up to the upper tribunal with basically E.ON challenging how the first tier tribunal had gone about dealing with the appeal and the preliminary issue. And the main points that came out of the case was E.ON was saying, well, we don't even hold the information. Surely that's a knockout blow. And well, that position wasn't accepted by the ICO or indeed Fish Legal, but the upper tribunal did a useful run through of the principles and the things that need to be looked at in the context of requests being made to the ICO and the powers to serve information notices in order to assist with the first question of whether or not the ICO has jurisdiction to determine the complaint, and indeed then whether the tribunal has jurisdiction to determine any appeal, and that you shouldn't put the cart before the horse by getting into the question of does the alleged public authority hold the information that's requested before you've determined the prior issue of is this a public authority or not. So it's a useful recap of the powers and the approach of the ICO and the tribunal that was first articulated in the fish legal decision back in 2015, and the sort of things that the tribunal, the commissioner need to look at. That's now gone back to the ICO for determination on the initial request, and in January of this year the ICO determined that E.ON was a public authority, and the analysis on that is quite interesting. They drew on the fish legal decision back in 2015, which were the water companies, as a sort of starting point. But there were some quite interesting factors that the tribunal, the ICO has picked up on in saying why E.ON was a public authority. It accepted it was no longer the owner or occupier of the wind farm, which is what the request related to, but it felt that it did have other functions that brought it within the scope of regulation 22C of the Environmental Information Regulations. Interestingly, obviously, unlike the statutory undertakers who were given specific powers and functions under the water legislation, in this case, what the ICO picked up on was the fact that, well, Ofgem has the power to grant licenses for electricity generation and gas generation, and in granting that licenses, Ofgem is in effect entrusting the license holder with the performance of a public service. And it also went on to identify various special powers, which are the pretty common ones we're seeing in these sort of contexts, so compulsory purchase powers and all the rest of it. But again, it's quite an interesting reasoning as to why the ICO thinks it came within Reg 22C, by reference to that licence having granted to it by another public authority. In a similar vein, another very interesting recent decision about public authorities is the Heathrow Airport decision. This was a request made to Heathrow Airport Limited in respect of various options reports to do with the airport to assist Aurora Holdings Limited in working up an environmental statement. Heathrow Airport Limited said, we're not a public authority. So the question that went for the ICO was, firstly, does it have functions of public administration that brings it under Reg 22C, or is it under the control of a public authority for the purposes of Reg 22D? And again, the ICO drew strongly on the fish legal case and also the cross and ICO, which immediately followed the fish legal case. And again, it's a very interesting analysis of what it is or why it is that they found the Heathrow Airport Limited was a public authority under 22C. Was it empowered with the relevant function under statute? Yes, it looked at the history of how airports were privatised and the powers that were given to them under the Airports Act, and considered that there was a direct and continuing link between the original transfer of functions and powers from the British Airport Authority in 1986 through the Act to the point where we got to Heathrow Airport Limited today. Then were at least some of the functions it was entrusted with related to the environment? Again, yes. And the ICO is obviously now taking a slightly more expansive view of what's meant by functions entrusted related to the environment. They don't have to be functions that are necessary. It doesn't have to be one that's specifically granted to manage the environment. It's enough the delivery of the service or the function that's been entrusted to the body has an impact on the environment, and perhaps unsurprisingly, it took the view that the operation of an airport such as Heathrow undoubtedly has an impact on the environment. So that's what got it into that box. Did it have special powers? Yes, it had a number of special powers as airport operator or statutory undertaker under the Civil Aviation Act 1986. And again, it looked at a number of other powers which are, again, common themes that are coming up in the ICO's decision making. So the power to make bylaws, power to charge for use of the facilities, power to levy penalties for breaches of requirements. And then it moved on to do what it called the cross check, which was something that had been done in cross, which is, well, you may have looked at all those boxes, but you stand back and look and say, does this really look like it is the sort of thing that ought to be a public authority for the purposes of the EIR regs? And again, that I've set out the crux of the ICO's reasoning on that point, in terms of whether it's performing service of public interest. They looked at the importance of the operation of it on the economy and the citizens of the UK, that previously had been under the operation of the state. and that given the continuing significance of the airport to the UK transport network, there was sufficient connection between its operation and the functions performed by the state. Didn't need to go on and look at whether it was under the control of the public authority, given its conclusions on Reg 22C, but just to note, the ICO decision is currently on appeal, I understand. In terms of mixed information exemptions, just two cases to mention briefly. Court of Appeal last year in Department for Transport and Information Commissioner has confirmed the approach that's got to be applied to where you have mixed information, so information some of which environmental, some of which isn't environmental, and that's to follow the approach of the Court of Appeal in the Henny case from 2017. And just one case on exemptions, an interesting, perhaps, a decision in which the legal advice privilege exemption wasn't enough to withhold the information because it was felt that the public interest in disclosure of the information, which in that case were instructions to counsel, outweighed the public interest in legal advice privilege. I should stress that those instructions were regarded in some degree as being historic, but it is just one to note that the ICO will in cases obviously find that even LPA documents may still be required to be disclosed under the EIR. Now, in terms of the quiz, I'm afraid, having taken you through a example warm-up quiz, the questions in my presentation are more in the nature of a survey, so they won't come up on the screen in front of you. They will just come up on your other browser or other device that you're using. And this is it's a survey. It's completely anonymized. The results won't come up on the screen, as it'll become apparent when you see the question. The question essentially being whether you think the ICO has taken too restrictive or too expansive an approach to its definition of public authority under the regulations. And if, when your survey is complete, you can click, I think it's finish at the bottom of the page, that would be great. And I will I will find the information on the web browser and let you know the outcome of each of the 3 surveys that will be in my talk at the beginning of the Q&A session at the end. On that note, I'm going to try and move on to the next topic, which hopefully this will allow me to do, although some surveys are underway. Second point I said I would pick up on is standing. Everyone will be familiar with Article 9.2 of the Aarhus Convention, the obligation for each party within the framework of its national legislation to ensure that members of the public concerned having a sufficient interest or maintaining impairment of a right, where that's a precondition of national law, have access to a review procedure before a court of law to challenge the substantive and procedural legality of any decision, act or omission, subject to the provisions of Article 6 or where so provided under national law, and without prejudice to what's mentioned elsewhere in Article 9, other relevant provisions of the Convention. So obviously the Aarhus Convention isn't directly applicable in domestic law, but it's found its way into it through things like the EIA regulations via the EIA directive and the SCA directive, which I know Andrew will be speaking about more shortly. Obviously, the question of sufficient interest is one that's got to be determined in accordance with national law, but also consistently with the objective of giving the public concerned wide access to justice within the scope of the Convention. NGOs are expressly in, that's Article 9.2. I've just set out obviously the domestic inverted commas tests. The individual companies, you're looking at the question of whether their person is aggrieved if you're in the context of a statutory review, or if you have sufficient interest in a judicial review. As you all know, that latter one is an elastic concept that will depend on the circumstances and the context in which the challenge is being brought. But a question that's floated around intermittently is the question of unincorporated associations. Obviously, we're all familiar with the action groups, and the action groups who end up incorporating in order to bring challenges to judicial review claims or to claim Aarhus cost protections. But there has been a bit of issue around these unincorporated associations, and this has been dealt with fairly comprehensively in a recent decision of Mrs. Justice Lean, the Airborough Neighbourhood Development Forum and Leeds City Council case. Now, in that case, there was a direct challenge taken by the defendants and interested parties to the legal capacity of the Neighbourhood Development Forum to bring the challenge at issue. And they were seeking to challenge a site allocations plan for Leeds City Council. The defendant argued, amongst other things, that the forum just wasn't a person, it wasn't a legal person, so it couldn't be a person aggrieved. The interested party also, I mean, it was a commonality of arguments between all on the respondent's side, but the second interested party argued in particular that there was a distinction to be drawn between judicial review and statutory review proceedings, particularly looking back at the case law. And after a very thorough review of the cases on this issue to date, including ones where it hadn't been dealt with, but it's sort of essentially been assumed, for want of a better word, that the claimant could bring the challenge. Mrs. Justice Lean concluded that, yes, unincorporated associations like the Forum did have legal capacity to bring judicial review and statutory review proceedings. She didn't see a distinction between those two sets of proceedings. Obviously, that she found there was a distinction between private and public law proceedings. Private proceedings, the need for a legal person to have a right that they're asserting, but in public law challenges, it really being about somebody bringing to the attention of the supervisory jurisdiction of the court an issue, stressing that was a slight difference, and that the critical question is whether or not they have standing to challenge, which wasn't strict legal capacity, but sufficient interest in the decision not to be a mere busybody. Why I've brought up this case in particular in this context is because of the express reference that was made to the Aarhus Convention in that case. And again, obviously it's not directly applicable in domestic law, but it's this theme that's picked up in the passage I set out in bold, which is the guidance from Article 9.2, that obviously sufficient interest is a matter of national law, but you should look at it in the context of the objectives of the convention. And we can just see that slightly reflected at the end of paragraph 31, that idea that the Aarhus Convention obviously does support a broader approach to standing where you're trying to vindicate convention matters. Just two other things I wanted to mention very briefly, because I'm conscious of time. On standing, a recent decision of the CJEU, the proceedings brought by the Wasserleitungsverband Nordliches Burgenland and others, and I apologise for the missing umlaut. And this was an attempted challenge that was brought by a water association, which was legally obliged to supply water in an area. An individual who owned a domestic well, and the municipality of Svingdorf, which operated a municipal well, where they were trying to bring a claim requiring an amendment to regulations that had been enacted in order to give effect to Article 5.5 of the directive on protection of drinking water by reference to nitrates from agricultural sources. And the domestic courts basically, you can't bring that. And so the first issue certainly before the CJEU was, well, were sort of these individuals able to enjoy directly enforceable rights under the directive, so that they could challenge domestic legislation or require a change to domestic legislation to give effect to those rights. And the CJEU started by looking at its own case law, understandably, on the issue of standing and the need to ensure effective protection of rights that were conferred by the European instruments. What was really interesting, and it's a theme that's coming up a bit more in the CJEU jurisprudence as far as I'm aware, is the express drawing on the express reference to the provisions of the Aarhus Convention. So again, we see at paragraph 33, there's the express linking of the rights in Article 9.3 of the Convention, and reading it with Article 47 of the Charter of Fundamental Rights of the European Union, and also at 34 that the right to bring proceedings set out in Article 9.3 of the Convention would be deprived of all useful effect and substance if they're read too restrictively. So again, just a bit of a theme that's emerging in the CJEU's approach to drawing on the Aarhus Convention in informing those sort of decisions. And just for interest, because it's a case I found a while ago, and I think it's an interesting direction of travel that we're seeing in other European countries, is a decision, I've given you the newspaper link there, to a court decision in France, where individuals brought a an action saying that the state had failed to fulfil its air protection plan, which is intended to counter pollution. So again, an idea of perhaps this sort of broader idea of standing and actions that individuals are able to bring in part in reliance on the sort of protections that are conferred by the Aarhus Conventions and are finding their way through European legislation into to domestic courts. Which brings us to effective public participation. And again, I know Andrew was talking about COVID-19 and the SEA regulation consultation, so I'm not going to spend too long on this. But just another interesting case, a recent decision of the CJEU in the case of Flausch and others. Now, this was a challenge that was brought to a proposal to consent a proposed hotel and spa on the island of Byass, which development would have been was subject to EIA. Now, the notice was published in the local newspaper circulating on Syros, which was the head of the municipal administration headquarters for that part of Greece. The EIA file was kept on Syros, and the decision approving the project was published in that local newspaper at the regional headquarters and on the minister's website. The claimants, who I think were habitually resident in France and the Netherlands, didn't find out about this until after the time period elapsed under national law for challenging those decisions. And so it ended up in the CJEU. And a number of questions referred to them on the interpretation of the EIA directive. And it was largely around, is it compatible to have a decision, for decision making to be made on one island if about development on another island? I'm paraphrasing horribly. But why I flagged this case and why I think it's really interesting is in terms of the comments by the Attorney General and also by the CJEU about effectiveness of measures and needing to ensure that the measures that have been adopted by national states are effective to protect the public participation rights under the EIAD. Obviously, they stress that in the first instance that's for the National Reviewing Court, but it did make some comments on a few of what it thought is potentially problematic with the effectiveness of the procedures that have been adopted, particularly around the ways in which the public was informed of the project's existence and how consultation was to take place. And paragraph 32 is interesting, as is paragraph 53 of the Attorney General's opinion, that the competent authorities must ensure the information channels used may reasonably be regarded as appropriate for reaching the members of the public concerned, in order to give them adequate opportunity to be kept informed of the activities proposed, the decision-making processes and their opportunities to participate early in the procedure. And obviously that was looking very much at a procedure level. But obviously I think there's going to be some interesting issues around over the next little while around whether or not the procedures, the usual procedures for advertising EIA, SEA developments have actually been effective. Given the current situation that we're all dealing with. So I just thought it's an interesting case to flag, particularly if anybody is maybe looking at whether or not the particular situation they are dealing with might have any problems with it, either from the perspective of those who are actually trying to do the consultation or the advertisement, or those who feel they haven't had an opportunity to properly participate, just to look at some of the consideration that's been given to the CJEU in that case, in the context, as I say, of the EIA directive and what that may mean going forward. So that comes on to the second survey, which is Aarhus post-Brexit. And essentially by this question, it's, do you think that the UK should remain a signatory to the Aarhus Convention once Brexit's been completed? I think the options are yes, no, or does it really make a difference anyway? Again, I will try and get the results of that and read them out at the beginning of the Q&A. I'm conscious of time, so I'm just going to move briefly on to the next and final topic whilst that survey is underway. Costs. Just two things to be aware of. Sorry, I don't know what's happened to that slide there. Two cases, a couple of cases to be particularly aware of. Firstly, a decision last summer of the Court of Appeal in the Campaign to Protect Rural England, Kent branch, and Secretary of State for Communities and Local Government. This was a case where permission on a Section 113 challenge to a local plan had been refused on the papers, and there was an Aarhus cap in place, but the judge on the papers awarded costs to the defendant, the Secretary of State, the local authority, and to the interested party developer. And there was a bit of an issue about whether the Secretary of State should have been the first defendant or the second defendant or all the rest of it, but the judge declined to change the identity around, given she'd not heard from the claimant in response to the defendants on that point. But the total costs that were awarded went up to the £10,000 cap in place in that case. And the claimant didn't renew the application for permission to apply for review, but appealed to the Court of Appeal against the costs award that had been made by the judge on the papers and which had been essentially affirmed following written representations from all parties. And the main argument was, well, look, if we look at Bolton NBC says when you're in a planning case, really there should only be one set of costs. The defendant should get their costs. It should only be in exceptional circumstances where there's a second award of costs to an interested party or second defendant, and that's the approach the court ought to have applied at permission stage. And it said, Mount Cook just doesn't directly deal with that point. The comments are obiter, and it wasn't really dealing with that. Now the Court of Appeal has essentially confirmed the approach in Mount Cook is the one to be followed, that as a starting point, the defendant and the interested party who respond by putting an acknowledgement of service are in principle entitled to the cost of that where permission is refused, but subject to the overarching protections of proportionality and reasonableness that are inherent in the CPR cost regime themselves. And they said, well, look, yes, Bolton was the pre-CPR regime. This is a new regime, essentially endorsing the reasoning that had been set out in the Luton Borough Council case and in Mount Cook, and a couple of other cases were cited. They also said, well, the approach to awarding costs is the same in a case where there's an Aarhus cap as where there isn't an Aarhus cap. And by that, what I mean is that it was argued by the claimant that, well, it's not right that the whole of the cap, the whole £10,000 has been used up at permission stage. The cap's meant to be there to cover the whole proceedings. How can it possibly be reasonable if the whole of the 10,000 is used at permission? And the court said, no, that's not the way to look at it. The CPR doesn't provide for staged caps. It hasn't set one limit for permission and one for the substantive. That's just not what the rules say. And that essentially, when I say the usual approach applies, you do the usual summary assessment and the cap comes in essentially as an upper limit on the cost you're actually entitled to pay. Now, permission to appeal has been granted to the Supreme Court, and the appeal I heard recently is listed to be heard in January. So I think we will finally get the final say on Bolton versus Mount Cook at permission stage. So watch the space on that one. But one interesting thing that has come out of the CPRE Kent, which I've queried as whether it's an unintended consequence, is the cost of interested parties. Now, CPR Part 45, Part 7 makes no reference at all to interested parties. It only talks about costs as between the claimant and the defendant. And there was a bit of this was sort of brought up in argument before the Court of Appeal, but more in the context of, well, can the interested party even have their costs in an Aarhus claim? Because look, Part 45 only refers to claimant and defendant. And then there's a comment at paragraph 47 and followed up in paragraph 48 of the judgment by Lord Justice Colson, where he essentially says, I'm in no doubt the absence of any express reference to interested parties in Part 45 is of no consequence. It was probably deemed unnecessary by the draftsman to refer to it every time after the defendant was mentioned. But in any event, it makes no difference. And that was in the context of, well, it's the cap protects one party, it's not about the substantive entitlement to the other. But what's quite interesting is what paragraph 47 has been taken to mean or used for. And just two cases I wanted to mention. Firstly, Kent and Teesside Magistrates Court. Now, in that case, the interested party disputed that the claim was an Aarhus Convention claim, and they were ordered to pay the costs of determining the point. And they said, well, hang on, CPR 45 doesn't make any reference to this. It only talks about claimant to defendant. And the court said, no, paragraph 47 of CPRE Kent, and you disputed it, and the usual position in 43B is if the defendant unsuccessfully disputes it, then they should ordinarily pay the costs. Interested party, you pay the costs. And I'm also aware of it in the context of interested parties having now applied to vary default cost caps and the court having said, well, yes, it seems they are entitled to do that. See paragraph 47 of CPRE Kent. So I do just flag whether that has been an unintended consequence of a passage which wasn't really that a matter at issue in the CPRE case. It'll be interesting again to see where that one goes. And finally, to bring my presentation to a close, a final survey, and this is essentially, do you think that interested parties should be able to apply to vary the default cost caps under the rules? Yes, no, or only in exceptional circumstances? And whilst that is in place, I will now move on and introduce our next speaker, who's Andrew Byass, who's speaking on SEA, the scope of application, the standard review, and update. So without further ado, over to you, Andrew.
Thank you, Jacqueline. I think I'm just waiting for control of the screen, which I think I've got. Just one moment. Bear with me, I'm just waiting to make sure I can control the screen. There we go. So 3 topics that I've got today. Consultation, the scope of the application of SEA in light of the Friends of the Earth judgment. This was a challenge to the National Planning Policy Framework, and the standard review of environmental statements in light of the Plan B Earth challenge, the Heathrow challenge, in which a fairly wide-ranging challenge was made to the standard review. As it happens, the last of those cases, the Plan B Earth case, also had Friends of the Earth as a claimant. And they also had an SEA ground, which they succeeded on, which related to the need to take into account the Paris Agreement. That the need to take into account the Paris Agreement was the subject of a number of heads of challenge. But that was the only one that succeeded so far as SEA was concerned. There was a far more wide-ranging attack on the appraisal of sustainability, the SEA. The appraisal of sustainability was prepared under Section 5 of the Planning Act and stood as the environmental statement for the purposes of the SEA regulations in that matter. And the more wide-ranging attack was made by the group of claimants comprising the 5 London boroughs, the Mayor of London and Greenpeace, and was a fairly root and branch attack on the AOS, which started from the premise that courts should in effect decide for themselves whether an AOS was or was not adequate, rather than applying an orthodox Wednesbury approach. Interestingly enough, FOE, Friends of the Earth, didn't argue for the same heightened standard for their SEA ground in relation to the Paris Agreement. They were content to apply a Wednesbury approach and indeed succeeded on that basis. The climate change Paris Agreement related points on which Plan B principally and Friends of the Earth 1 have been appealed. And you may already know that the Supreme Court decided last week to grant permission to appeal in respect of those matters. That doesn't, however, affect what I'm going to talk about today in terms of the standard of review, since the matters relating to the standard review and the approach to certain aspects of the preparation of environmental statements, i.e. the claims brought by the boroughs, the Mayor and Greenpeace, were refused permission to appeal. So the Court of Appeal decision is the final word on those matters. I'll come on to what those arguments were and what was decided in due course. Like Jacqueline, I've got a couple of questions. I'm dealing with consultation first of all. So the first question I have in terms of consultation is, in principle, do you think there should be an option for internet-only consultation on environmental statements, for example, on a dedicated website? So the overwhelming majority of you think there should be, which is perhaps not surprising given the format within which this talk is being given. But just interested to hear from the 11%, to be honest. From that 11%, if your answer was no, can you try to identify the main reason? I've given some options here. The internet's not sufficiently accessible, reviewing material online is not the same, or there should always be multiple ways to review environmental statements. Just interested in seeing what the information or the reason for the response was. So here we go. So a range of views, but the principal concern, as we can see there, the internet is not sufficiently accessible to enough or all members of the public. Well, I'll come on to talk a bit about that, but I want to put that in context as well of the provisions in relation to EIA and SEA, dealing first with EIA. The consultation provisions relating to environmental statements for EIA are found in the EIA regulations, and obviously elsewhere in other related regulations. They're generally the same, and the underlying text is what is important. In terms of the availability of copies of environmental statements, the obligation is to ensure that a reasonable number of copies of the statement are available at the address named in the notices. So there has to be the opportunity to inspect, which gives rise to difficulties in the present circumstances of lockdown and travel restrictions, and whether or not, even in light of revised guidance given last night, it would be essential to travel for the purposes of work to go and inspect an EIA, which I suggest it wouldn't be. The provisions in relation to SEA are similar, and there is a similar obligation in respect of the environmental statement to inform public consultees of the address, which may include a website, but can't exclusively be a website, at which a copy of the relevant documents may be viewed. So there is the same difficulty, even taking account of the potential easing of restrictions. These provisions effectively prevent, or at least arguably put a block on consultation, and so the progression of any new EIA project or any new plans and programs. And I think there are strong arguments that can be made to make provision for at least for internet-only consultation in current circumstances. Now, Jacqueline made reference to the case of Flash. There would obviously be a need to have regard to that, and the test in that case of whether internet-only consultation did give an adequate opportunity to be kept informed of activities proposed. And very likely a need to twin internet-only consultation with a mail drop of some kind, notifying people of where an environmental statement was to be found. There's also strong arguments, I think, for considering how internet-only consultation might work even beyond current restrictions. Plainly, there would be the arguments for retaining the ability to seek copies of any documents. But if there was internet-only based consultation, members of the public could print out relevant documents for themselves, obviously. And this is in effect how EIA works now in a development decision-making context, by the obligation on local planning authorities to publish environmental statements on their websites. But there remains the obligation to inspect a hard copy. Personally, I think it takes rather more effort to visit an address rather than just to view a statement online, or even to request a hard copy provided at reasonable cost. But obviously, different people have different levels of comfort with internet-only based solutions. And so it's going to be something that I think should be looked at. And in a world in which many of us have become more comfortable with online resources, witness this webinar, it strikes me that this is an area in which reform could well take place in the future. Turning then to the scope of SEA, I thought we could start with another question as soon as we get to the next slide. So again, get ready to compete. The SEA question, something for the planner acts. When may an SEA not be required? Multiple choice question. If the SEA relates to small areas, is a minor modification of an existing plan or program, is a financial budget or program, or all of the above? Turning then to the results, all of the above. Well, you're right. The majority of you, it is all of the above. An SEA isn't required if effectively it is going to have effects that will amount to likely significant effects on the environment. And if it is a small area, or there is a minor modification involved, or arguably if there's a financial budget plan or program, that won't arise. And so the purpose for which SEA is required isn't triggered. But obviously each of these matters requires an element of judgment, and there will be differing views on whether or not an area is sufficiently small, or the modification is sufficiently minor, or whether or not the financial budget plan or program in truth relates to matters that set a framework for development consent going forward. It's not necessarily clear cut whether or not you will fall within these exceptions. There is much existing guidance on the scope of SEA. Much of this was helpfully reviewed in the recent Friends of the Earth decision by Mr. Justice Dove. But just to be aware, this slide is here for, that there remains helpful Commission guidance, and to remind viewers that the approach that has been taken in the authorities has been very much one that seeks to guarantee that relevant plans and programs do not slip through the assessment net. As I think it was put in the HS2 challenge, the Buckinghamshire case by Lord Carnworth, the purpose of SEA is to ensure that the decisions on development consent are not constrained by earlier plans, which have not themselves been assessed for likely significant environmental effects. So that's the broad purpose within which the CJEU has acted in taking a broad approach to the scope of SEA. So the Friends of the Earth challenge sought to rely on that principle, that broad approach. And the challenge was to the MPPF, and more particularly to the revised MPPF that was published in July of 2018, and was argued that the MPPF was a plan or programme as so defined in Regulation 2 of the SEA regulations and the SEA directive. And the Secretary of State's arguments in response were that the MPPF fell in areas where a plan or programme is not required. And the issues were, first of all, was the MPPF required by legislative, regulatory or administrative provisions, which is one of the requirements for SEA set out in Article 2A of the SEA directive? Or secondly, did the MPPF otherwise set the framework for future development consents of projects? Now, as we'll get to, there is, I think, a clue in the title in terms of whether or not the National Planning Policy Framework sets a framework. But the first issue with which Mr. Justice Dove grappled was whether the MPF was required in the sense that the SEA directive had been interpreted by the CJU in various decisions, including or starting with the Brussels case. And in the Brussels case, which is what Friends of the Earth drew heavily on in their submissions, the CJU had effectively skewed the literal meaning of the word required in order that it should instead be understood to mean regulated. So there's been effectively a debate in some authorities, including a debate between the Supreme Court and the CJEU, about whether or not one should take a required approach or a regulated approach in terms of the application of the directive. In the Brussels case and in subsequent cases, including post the HS2 decision where the Supreme Court had commented on this, the CJEU has held that the fact that the adoption of a plan or programme is not compulsory doesn't mean that it's also not required. And what the courts have decided in Europe is that where plans or programmes whose adoption is regulated by national legislative or regulatory provisions which determine the competent authorities for adopting them and the procedure for preparing them, then they must be regarded as being required for the purposes of the directive. Now, as I said, in HS2, the Supreme Court expressed serious reservations about this approach, but didn't need to decide the issue because the command paper in issue in that case was concluded not to set the framework for HS2. FOE, though, sought to build on the CJEU's case law and argued that the MPPF is an integral part of the planning system. They relied on various strands of argument, first of which was that the preparation of local development plan documents are judged against national planning policy, see section 19.2 of the 2004 Act. And they also sought to rely on other provisions, such as those relating to neighbourhood orders and plans and the duty to contribute to sustainable development, which is found in section 39 of the PCPA 2004. All of these points being used in order to demonstrate the integral feature of the MPPF to the planning system in the UK or in England and Wales. And it was said that the planning system would in reality come to a halt or be fatally flawed without national policy. So in that sense, the MPPF was required by the legislative, regulatory or administrative provisions. The argument was rejected by Mr. Justice Dove, however, and in respect of section 19.2, for example, he held that the statutory provisions do not either mandate or regulate the production of national planning policy. For instance, in relation to section 19.2a, a development plan document could continue to be produced even if national policy did not exist. The absence of national policy would not mean that the preparation of local development documents would have to be abandoned. Thus, section 19.2 and its reference to national policy does not regulate or prescribe the need for the existence of national planning policy. And while there is a power to preclude national policy, to produce national policy, I should say, that cannot in effect be read as either a duty or regulatory provision for the production of that policy. So Mr. Justice Dove, in effect, didn't need to go any further. That, in reality, was the end of the challenge. Being required, or at least regulated by relevant provisions, is a necessary condition for the application of SEA. But Mr. Justice Dove nonetheless went on to consider the arguments about whether the MPF set the framework. And here he found the claimant to be on far stronger ground, and concluded that the MPPF did set a relevant framework and cited numerous aspects of the framework which supported that conclusion. Greenbelt policy has its foundation in national planning policy, and other examples were also given in the judgment relating to the sequential flood risk test, the criterion tests for development in national parks, and tests, for example, relating to irreplaceable habitats and heritage assets. So an unsurprising conclusion in terms of national, the MPPF setting a framework, but the ratio of the decision comes back to the fact that there was no requirement or even regulation in relation to the production of the MPPF, which brought it within the scope of the SEA. Is this an ongoing issue? Well, potentially. Required or regulated, the debate that has existed in the authorities over the last number of years may come back alive in a post-Brexit world. With the UK's departure from the EU, we may see a shift back to a more purist approach to the required regulated debate. If there is such a shift, obviously, careful regard would need to be given to the purposes of the SEA directive, and effectively to ensure that there is a proper environmental assessment of plans or programmes which do set a framework for decision making. And if there is a shift in focus, no doubt the courts will have regard to the history of the provision in seeking to apply any amended definition going forward. So far as future challenges are concerned, there is a potential challenge by Transport Action Network to the Road Investment Strategy 2, which is the strategy that sets effectively the budget for the investment in the strategic road network for the next 5 years. I think there's something in the order of £27 billion earmarked to be spent on the SRN over the next 5 years. I'm acting for DFT in relation to that. I'm not revealing any confidence as though in quoting from the pre-action letter, which is on the Transport Action Network website. And you can see from the quote here from the pre-action letter that the arguments that are being made is that, first of all, the road investment strategy is required by law, and the reference there is to the Infrastructure Act 2000, and that should be 2015, which set up Highways England as a separate independent company and prescribes the procedures in relation to how a road investment strategy is produced, and also makes the argument that the road infrastructure strategy sets a framework for future operations, maintenance and development consent, and stipulates a locational and funding framework. So there may yet be further judicial action on what it is that, what the scope of SEA is in the context of something such as the road investment strategy. And there may well be the potential for other challenges, including, as I say, in a post-Brexit world. Moving on then to the standard review, the final topic I'm going to be talking on today. And the Plan B case. Airports development has obviously been a controversial issue for decades, not least development at Heathrow. The latest phase has seen the work of the Airports Commission leading to the recommendation to promote airport-related development at Heathrow through the mechanism of the Planning Act and the development by the government of a national policy statement. There was no question that an SEA was required of the airport's MPS. And as I mentioned earlier, what in fact was prepared was an appraisal of sustainability, which is required by Section 5 of the Planning Act, which also counted as the environmental statement for the purposes of SEA. The whole prospect of aviation expansion obviously is an interesting issue in light of the current crisis and the extent to which the aviation industry will recover. It's not necessarily a straightforward question of expansion stopping, I think, but it does not take a crystal ball to say that there will almost certainly be impacts on demand. Which leads me to my next question, which is already out of date compared to some news reports I read this morning, but I'll ask the question, then I'll give the update. So Heathrow, by how much did passenger numbers reduce in March 2020 compared to March 2019 at Heathrow? So the options here, reductions of 90%, 70%, 50%, or 30%. So this is through March. And I read this morning that in April, the total passenger numbers were 200,000 people. And in fact, that is the same as a normal day at Heathrow. In March, we went into lockdown about halfway through, so it was 50%. So 50% reduction in March, but I think it's probably about 2% in April, which is a staggering reduction in the amount of people flying. So the argument of Plan B Earth, as I say, not concerned so much with the successful challenge in relation to Paris, which succeeded on straight Wednesbury grounds, but the argument by the boroughs, the mayor and the Greenpeace was that there was a legal requirement under the SEA directive that the information in an environmental statement is sufficient for the purposes of the SEA directive, and whether this requirement has been met is a matter for the court. The effect of a Wednesbury approach, it was said, would be that if the authority responsible for the preparation of the plan or programme is able to point to some information that can be said to address the requirements of the SEA directive, the court will take a very hands-off approach and will not examine the adequacy or quality of that information. This meant, in legal terms, that a normal Wednesbury approach was insufficient, and in practical terms, that there would be the need for competing expert evidence on topics, arguments about sufficiency of analysis, detailed evidence before the courts, and so the lengthening of hearings. And this was borne out by the Heathrow hearings themselves. There was an enormous amount of evidence produced on technical topics relating to the assessment of noise, the methodologies used to prepare the AOS, the approach to assessing plans and programmes, and other matters which required an enormous amount of resources and took a very large amount of court time. The Divisional Court's answer was quite straightforward. It rejected these submissions and effectively said that the approach that should be taken, by analogy to the approach that's taken in EIA, is that classically set out in Blewett. And this is a wonderful quote. It's in an imperfect world, it is an unrealistic counsel of perfection to expect that an applicant's environmental statement will always contain the full information about the environmental impact of a project. And then the last sentence, there will be cases where the document purporting to be an environmental statement is so deficient that it could not reasonably be described as an environmental statement as defined in the regulations, but they are likely to be few and far between. As the Divisional Court saw it, the Blewett approach doesn't represent a freestanding principle of law, but it's simply a practical application of the conventional Wednesbury principles of judicial review. And the Court of Appeal agreed. They pointed to the terms of Article 5 of the SEA directive in support of their conclusion that the court's role must reflect the breadth of the discretion given to it to decide what information may reasonably be required when taking into account the considerations referred to in Article 5.2. And those are first, the current knowledge and methods of assessment; second, the contents and level of detail in the plan or programme; third, its stage in the decision-making process; and fourth, the extent to which certain matters are more appropriately assessed at different levels in that process in order to avoid duplication of the assessment. These requirements, the court concluded, leave the authority with a wide range of autonomous judgment on the adequacy of the information provided. All this indicated, as I say, to the court that a conventional Wednesbury standard of review should be taken as illustrated in Blewett. As it said, if it took a more intense review of environmental statements, the risk would be that the court would be invited, in effect, to substitute its own view on the nature and amount of information. This would exceed the proper remit of the court. So applying this standard, the court rejected the claims by the boroughs that the AOS was defective for failing to describe in sufficient detail the relationship between the AMPS and local development plans, for example, and for failing to properly assess the environmental characteristics of the areas likely to be affected by increased noise. There was assessment of noise, and so the argument before the court was really about the adequacy of that assessment, and the court said, well, that's a matter of technical assessment, and the evidence before us demonstrates that the approach was sufficient. As I say, the succeeding ground of challenge in relation to SEA, though, by Friends of the Earth, was the failure to take into account the Paris Agreement. And the argument that was made there is that there was a reference in Annex 1 to the SEA directive, which refers to the need to take into account environmental protection obligations or protection objectives established at international level. And that must include unincorporated international agreements, because otherwise there would be no need to refer to the international level at all. Everything else has been incorporated domestically. And the court accepted those submissions, found that the Paris Agreement was an obviously material consideration that needed to be considered. But as I say, that is one of those aspects of the judgment that in respect to which permission to appeal has now been given. And so the Supreme Court is going to be giving us the last word on that. That concludes my talk. Thank you very much.
Good afternoon, everybody. I'm hopefully about to take control of the shared screen. I'm going to be talking on the domestic habitats regime, looking at the special scientific areas of special scientific interest, regime, the SSSI regime. And I've got a few questions to start with. The habitats issues are obviously a familiar one for all of us working in the environmental sectors and in the development industry. But in recent years, arguments have tended to focus on the EU aspects of that regime, principally in the principles now found primarily within the 2017 regulations. Now that regime, of course, remains in force, but as we move forward, and given what we know about the government's discomfort with certain aspects of that regime, it seemed like a good moment to remind ourselves of the domestic equivalent regime, of the SSSI regime, and its functioning in the light of current case law. So now we've got a couple of questions. So if you look at your secondary browser, the first question, giving us a sense of the scope of the regime, what percentage of the land mass of England has at the current time been notified as a SSSI? You've got three possible answers there: 0.7, 7, and 17%. The time has run out there. The answer is 7%, so 50% of us got the right answer there. Yes, so it's quite a substantial portion of England. It goes much wider than the Natura 2000 sites. I think we've got about 330 Natura 2000 sites in England at the present time, and over 4,000 SSSIs. So a broad area of space, including many urban, suburban areas where you wouldn't normally find SPAs or SACs. Our second sort of introductory question, this is a general knowledge point, but which Act of Parliament first introduced the SSSI regime? I've got 4 here: 1949 Acts, National Parks Act, Countryside Act, 1968, 1981, or the 2000 Act. That's definitely in the Planner Acts category, that question. How have people done? 79% of you have gone for the 1981 Act. That box has been ticked because I've managed to misidentify, but in fact, SSSIs were first introduced by the 1949 Act. There was a version of SSSIs that existed at that time, although, as we see, they've been substantially, in fact, almost entirely revised and are now contained within the 1981 Act. So I understand and obviously have followed everybody else in going for the 1981 Act, but the actual answer is the 1949. So a quick slide just to show the scope of my talk. I'm going to do an overview of the scope of the SSSI regime, of the various controls contained within it. I'm going to have a fairly detailed discussion of the Natural England and the Warren decision, which I think is of critical importance to anybody acting, anyone considering issues around SSSIs at the moment. And then I'm going to offer you some thoughts on the adequacy and potential role of the SSSI regime going forwards post-transition period. I've set out there a very brief history of the SSSI regime. It was, as I say there, first created under the 49 Act, but substantially overhauled in 1981, when it was brought about, notably, I think, when we look at the broader function of the SSSI regime, it was brought in both to implement the Wild Birds Directive, but also to implement the 1979 Berne Convention on the Conservation of European Wildlife and Natural Habitats, a convention which formed much of the backdrop to the development of the Birds Directive, and to which we are still a signatory going forwards. There was then significant amendments made through Part 3 of the 2000 Countryside and Rights of Way Act. That significantly increased the range of controls which particularly Natural England were able to exercise, and that was done in part to reflect UK international obligations under the Rio Convention. Since that date, the SSSI regime has operated in tandem with the habitats regime, and in England at least, all SSSIs and SPAs are also SSSIs, although obviously it doesn't apply vice versa. Now in this slide, I've tried to help us break down the various ways in which SSSIs as habitats are regulated. So looking at the first column on the left, there are various limitations on activity by owners and occupiers. And that process really depends on the operations which are notified by Natural England as being potentially damaging. That's part of the requirements which Natural England and the Secretary of State are under when establishing SSSIs, and there must be a list of operations which the nature conservation body believes will or may harm the special interest of the site. But it can also, and has in many cases, been varied subsequently. So there's an ongoing process of crystallizing and specifying the operations which it's believed may cause harm. So common ones will include release of animals within a SSSI, or various land management activities, or indeed changes to land management activities. Once an operation has been identified as potentially damaging under section 28.4, a consenting regime is then imposed. So it is an offence to breach without reasonable excuse the requirement to have a consent from Natural England in England and Natural Resources Wales in Wales for carrying out that activity. There are a number of different ways in which that requirement is dealt with by the conservation bodies, some of which are currently under challenge, but in a series of judicial reviews brought by Wild Justice, particularly relating to the control of game birds and other wild birds. But generally, there's been an approach to either grant general licenses, which can be used subject to conditions in any part of England or Wales, respectively, or specific licenses under maybe a yearly renewing scheme, or sometimes licenses have been granted indefinitely. That's the primary form of regulation in relation to owner-occupier activity. In relation to third-party activity, there is a power to make bylaws. These bylaws are actually made under the 49 Act, and there is a stipulated list of things which can be regulated through those bylaws. There's also a freestanding offence, so individuals or corporations can be prosecuted for damage to the special features of the SSSI under section 28P, subject to normal defences. And then there's also a duty on statutory undertakers and other public authorities to take reasonable steps and seek consent where they believe there's a risk of damage. So that's the regulation of third-party activity. Finally, thirdly, we've got the proactive management measures. It's always been the preference of the regulators of the nature conservation bodies to reach agreement with landowners in particular where possible, and that the 1981 Act provides for a series of measures which can be used by the nature conservation body to set out a scheme of management. These include statements which are made by Natural England when designated, when notifying an area of land as a SSSI, schemes which can be agreed between Natural England and the landowners, and then notices which Natural England may serve when it's been unable to agree a scheme with the landowner. There's also, in relation to SSSI, and I think critically in many cases, a range of other systems which interact with the SSSI regime. Now, I think that one of the issues that we're going to face going forwards is that, as you can see from that list under my fourth column, two of them are European law derived. So the habitats regime imposes a requirement through the 2017 regs for all the SSSI powers to be exercised so as to ensure compliance with the habitats regime. And obviously where a SSSI is also an SAC or an SPA, the range of extra controls that relate to habitat sites, European habitat sites, also apply to protect the SSSIs. Those will include, not beyond the consenting requirements I think we're all familiar with, powers such as the power to make a special nature conservation order in respect of other land outside where activities may have a negative effect on the conservation objectives of the site. There's also, of course, the environmental liability regime with its strict approach to damage and the obligations on parties who cause that damage. Finally, there is the planning system. Natural England's a statutory consultee under the Development Management Procedure Order, and when applying for planning permission for development, developers will need to meet the terms of NPPF 175B in particular. So the strengths and weaknesses of this system, once we step away from the European-derived legislation, which may or may not be subject to change going forwards, are, I think, significant. So within SSSIs, activities may be controlled, but only if they fall within, well, may be controlled prospectively, but only if they fall within potentially damaging operations. Management statements and schemes can, of course, continue to be made, as well as bylaws, but it all requires proactive work by Natural England or NRW. However, in terms of other restrictions on prospective development, while development proposals themselves, so things that fall within the scope of the planning regime, will have to address paragraph 175, it's notable that if permission is granted under Part 3 of the Town and Country Planning Act, that will be a defence to prosecution. So if you can get through, the developer can get through the planning regime, then the SSSI regime doesn't provide an additional safeguard. Notably, Part 3 requires an express grant of planning permission, so that won't include permitted development rights and so forth. The test under the MPPF is also a much lighter one than the test that we're used to in relation to European habitats sites. When determining planning applications, local planning authorities should apply the following principles. Firstly, if significant harm to biodiversity cannot be avoided, it should be adequately mitigated or, as a last resort, compensated for. Otherwise, planning permission should be refused. That's the first relevant test. But the critical one, I think, is going to be B, which says that development on land within or outside of the SSSI, which is likely to have an adverse effect on it, should not normally be permitted. That seems like quite a strong test, but it's then qualified by the second half of 175B, which says the only exception is where the benefits of the development in the location proposed clearly outweigh both its likely impact on the features of the site that make it of special scientific interest and any other broader impacts on the national network. Now, that is quite a different position to the one that we're familiar with in the EU context, because it allows for a weighing exercise. The local planning authority is entitled to look at all the benefits of the development, whether they be economic, provision of needed housing, contributions to local infrastructure, whatever they are. The local authority is entitled to weigh those benefits as a matter of planning judgment against the impacts on the SSSI and on the national network. Now that is, I think, clearly a test that's much more open to grants of development consent than perhaps we might expect, not being familiar with the regime. So a lower test from the planning perspective. Also to be noted, of course, that the tilted balance is excluded, but yes, as I've already said, that is, it does appear to be a much lower test than applied under the EU habitats regime. Now, the strengths or weaknesses of the regime also need to be considered in relation to how well they control development or activity outside SSSI regimes. We've been looking at what can be controlled inside the SSSI itself, but many schemes, well, we're familiar again from the EU context that often the real issues arise when you have development or activities going on in the environs of a protected site, and the question is, will the increase in traffic, the increase in recreational users that results from whatever's proposed, will that lead to adverse impacts which need to be mitigated, or which can prevent the scheme from going ahead? Now, in relation to planning, the development proposals, it's effectively the same position whether you're inside the SSSI or outside, subject, of course, to the obvious issues that might arise as to how great an impact you're having on the special interest of the site. You've still got to address, the developer still has to address paragraph 175, and again, if permission is granted, that will be a defence to prosecution. But other issues arise in relation to non-development activities. So there are a range of activities which don't fall within the scope of the 1990 Town and Country Planning Act. And for example, in the case of Natural England and Warren, the release of game birds into the environment so that they can grow and then be shot for sport. I've got an introductory question just to check that we've all got high quality screens and that we know our natural environment. I'm afraid it's a game bird rather than a protected species itself, but what kind of bird is the following picture? We've got a red-legged game bird. So is it a pheasant, a grouse, or a partridge? I'm giving you 10 seconds for this. Time's up. It is indeed a red-legged partridge. Well done, everybody. Which brings us on to the facts of Warren. So Mr. Warren ran a commercial shoot in Suffolk. It was quite a large estate, and part of the estate only was designated as a SSSI. And the notification listed potentially damaging operations, a number of them, which included specifically, and of particular relevance for the challenge, the release into the site of any wild animal. Now, the shoot had been in existence for some time, but as I think is fairly common across many parts of the country, there had been increased commercialization, increased numbers of shoots on the site, and Natural England believed the scale of operation had increased in a way that was significant, and amongst other matters, they alleged that the game bird releases now being carried out risk causing harm to breeding and wintering protected birds invertebrates and heathland vegetation. They served a stop notice on Mr. Warren, which alleged the commission of an offence under section 28P, causing damage to the SSSI, or both causing damage to the SSSI, and also a separate offence, carrying out potentially damaging operations without the consent of Natural England. They sought the cessation of releases both within the SSSI and also, critical importance for this talk, within a zone of 500 metres around the SSSI. Now, Mr. Warren appealed to the first tier tribunal, which varied the notice in part, and then on Natural England's appeal to the upper tribunal, a number of issues were raised, which I should say I'm only going to be dealing with one of them, but for all of you involved in potentially involved in enforcement issues around a SSSIs, the decision has a number of issues which bear consideration for those specific contexts. But the particular issue which is relevant to this talk is the question was raised as to whether Natural England in fact had the power to serve a stop notice in relation to that 500-metre buffer zone at all. Were their powers restricted to activities within the SSSI itself? And that turned on whether the releases outside of the SSSI could, as a matter of principle, constitute an offence under either section 28P1, which is the contravention of section 28E, which is the requirement to have a consent for potentially damaging operations. So first alleged offence, carrying it out, releasing the birds without a valid consent, or secondly, the broader offence of intentionally or recklessly damaging features of special interest. Now, a great deal of the argument turned on the language of section 28E. So this is the requirement on an owner or occupier of any land included in a SSSI, while the SSSI designation remains in force, not to carry out or cause or permit any operation specified in the list of PDOs without notification and permission from Natural England. And you'll see I've emboldened key text. Firstly, it applies to owner and occupier of any land included in the SSSI, and then it says that they may not, while the notification is in force, carry out or cause operations on that land. Now, I'm conscious we're running a bit over time, so I'll keep licking through this. But Mr. Warren effectively argued that the duty and therefore the offence only applied to an operation on any land within the SSSI. And Natural England argued with some force that this would be absurd in the particular context that they were considering. If birds are released just outside of a SSSI, but it is obvious to everybody that they will, being birds, they will spread and they will go on to the SSSI, it was said that there's no logical reason to treat that differently from a release where the pen itself was within the SSSI. The question was where the birds went. It was also said that it would significantly undermine the regime if such operations could only be addressed by prosecution or stop notice. Firstly, often prosecution will, in their very nature, have to follow the event, so after harm has already occurred, or they will place a much higher burden on the nature conservation body than if there's a consenting requirement. The judge didn't accept that argument. She said that it was the duty only applied to land within the SSSI. She said it would be inappropriate, given the criminal context, to say that it would, to allow this to be spread, it would introduce too much uncertainty. And she also said that even if this meant that such activities could not be controlled, that was simply a consequence of the legislation. So in the light of Warren, the potentially damaging operation notification and consent regime doesn't apply. And it seems likely, looking at the legislation and looking at the decision, that Natural England's powers in relation to management schemes and notices are similarly limited to land within the SSSI. So going back to our overview, we can see we've got already in the fourth column, we're aware that two key parts of the regime are potentially subject to change in the light of Brexit. We also now know that owner-occupier activity isn't regulated outside of the SSSI, and it seems unlikely that proactive management will also be. Seems unlikely that will apply outside of SSSIs, nor the power to make bylaws. So, in relation to activity outside, there's a great deal of reliance on the prosecution powers, on the duties on statutory undertakings and public authorities, but also on the planning regime, which, as we've discussed, is a bit more limited. So, just thinking a bit about how this might function in the future. As I said at the outset, there's a clear political appetite for some form of watering down, and I would note, in relation to the most recent evidence from the Environment Bill, I'd refer you to David Elvin QC's talk in part 1 of this webinar about the significance of the commitment, the political commitment to non-regression being removed from the transition agreement following the general election. In my view, it's questionable whether the government, given the government's clear interest in making some changes to the habitats regime, insofar as the EU-derived habitats regime, it seems questionable that they would want to keep both the European regime and the domestic regime as they stand in their current form. But it's pretty clear that the SSSI regime itself is not going to be capable of replacing the 2017 regime, and there will have to be a great deal of care as to how the government amends the regime to put more weight perhaps on the SSSI regime than we've previously expected it to bear. It's a very different test. It has deficiencies in terms of its ability to deal with activity outside, and in the end, the MPPF test, that's a much lower development threshold for development. Also, a question remains as to whether the SSSI regime, considered on its own, would ensure consistency with the Berne Convention, which, as I mentioned earlier, we're still a signatory to. I've set out some of the key articles of that, and particularly Article 4.1, which, in terms of its language, very clearly is quite close to what we find in Article 6.2 of the Habitats Directive, and Article 4.2, which, while clearly doesn't go as far as Article 6.3 and 6.4 of the Habitats Directive, it does require the contracting parties to have regard to conservation requirements so as to avoid or minimise as far as possible any deterioration of such areas. Now, the Berne Convention wasn't discussed in the Warren case, so I think it's going to be some interesting areas for dispute here as we go forward as to how the SSSI regime sits with our international obligations there. I think I finished with a final question, and that is, what has happened to the part of the Foraven Links SSSI that lies within the Trump International Golf Course? And we've got a yes, basically yes/no question here. Has it either been protected and enhanced, or has its denotification been recently proposed? See what you think. And yes, sadly, its denotification has been proposed. So, in practice, example of the limitations of the SSSI regime as it applies to the protection of sites of special scientific interest. Thank you very much. I think that's the end of my talk.
Thank you, Matt, and thank you everybody for attending today. I think there have been a couple of questions, but in light of the time, we'll try and pick those up separately offline. Just a very quick update on the survey results from the questions raised in my talk. Do you think the ICO has been too expansive in its identification of public authorities? Yes, 19%, no, 39%, about right, 42%. Do you think the UK should remain a signatory to the Aarhus Convention after Brexit? Yes, 88%, no, 31%. I don't think it makes much difference, 9%. Do you think interested parties should be able to apply to vary the default cost cap? Yes, 35%, no, 17%, only in exceptional circumstances, 48%. So I think it just remains to say thank you very much, everybody, for attending today and for participating so enthusiastically in our attempt at making the technology even more complicated through the use of polls and quizzing. We hope it's been informative and useful, and I wish you all a very pleasant week.
Thank you, everyone.
Thank you very much.